Welcome back. You're watching The Firm. It's well settled that if two Indian parties are involved in an arbitration, then they must apply Indian substantive law to their case. But can two Indian parties choose a foreign-seated arbitration governed by a foreign law? Would that be against the public policy of India? Aayush Ailawadi analyses a recent Bombay High Court decision for some answers.
Recently, in the case of Aadhar Mercantile Private Limited versus Sri Jagdamba Agrico Exports Private Limited, the Bombay High Court was faced with an interesting question: whether two Indian parties could opt for a seat of arbitration at Singapore and whether the proceedings could be governed by English law. The uncertainty surrounding this question stems from a disjunctive clause in the original agreement between the parties, which stated that in case there was a dispute, the arbitration would be conducted in India or Singapore and that English law would apply. So the court held that since this was not an international commercial arbitration and Indian parties can't derogate from Indian law, the arbitration has to be conducted in India under Indian substantive law. Well-known counsel at the Bombay High Court, Tushar Cooper, says that the court has rightly decided the case in accordance with the law.
The court held that since the clause permitted reference to arbitration and the seat of arbitration to be either in India or Singapore, Section 28 of the Arbitration Act would be attracted, and therefore the Indian substantive law would be applicable in the light of Section 28. I can take you through the provision briefly if you wish, but by and large the court therefore held that 28 is applied and that by virtue of 2(6) parties are not capable of contracting out of Indian substantive law. In doing so, it relied substantively and heavily on a judgment of the Supreme Court reported in 2008, TDM Infrastructure, which held that in such cases it would be Indian substantive law which would apply. TDM Infrastructure went on a footing that and gave a restrictive interpretation to 2F, holding that even companies which are incorporated in India, notwithstanding the fact that the seat of management may be outside, would not be able to claim that Section 2F, holding that these were international commercial arbitrations, would be attracted. There may be some dispute about that, but that is not really germane or relevant in this case. For the purposes of this case, we must proceed on the footing that both companies were incorporated in India and had their management in India.
But Khetan partner Sachin Mandlik, who specializes in alternate dispute resolution, says that this Bombay High Court judgment could be interpreted to mean that Indian parties cannot opt for a foreign seat of arbitration.
As far as the judgment goes, the Bombay High Court judgment, by virtue of opting the foreign seat, what would happen, the impact would be that you will be parties will be permitted to derogate from the Indian law, because by virtue of the seat being the foreign seat arbitration, the part 1 of the Arbitration Act would not apply, and that would amount to the derogation from the Indian law, and ultimately, consequently, the result would be against the public policy. Therefore, today, by virtue of Aadhar judgment, it could be argued that it is not possible to have a foreign-seated arbitration between two Indian parties. Substantive law is one and the procedural law is one. But by virtue of this Aadhar judgment, we will have an issue here.
Interestingly, in arriving at this decision, the Bombay High Court doesn't seem to have considered that the Supreme Court thinks differently. In 2014, in Reliance Industries versus Union of India, a case with similar facts, the Supreme Court upheld the right of Indian parties to choose a foreign seat of arbitration.
The Supreme Court had the opportunity to deal with this aspect, where the Reliance was in dispute with the Government of India. There were contractual disputes. In that case, the substantive law, the contract was governed by the Indian law, the procedural law was the English law, and the seat was in London. So this was almost identical issue, one can say. In that case, the Supreme Court has held that both these parties can hold the arbitration in London. In fact, did not permit the Section 9 injunctive reliefs application in Delhi. So therefore, that judgment, I thought, should have been considered or possibly was not placed before the Bombay High Court and did not get an opportunity to consider that. So today, therefore, there is a little, the issue in a sense where the Supreme Court has decided this issue in this manner, as the Aadhaar has given some more, thinking now for the lawyers to decide whether the foreign seated arbitration would be permissible or not. Because the moment you say so, then the question comes in whether you are derogating from the Indian law, and then the Reliance judgment is also can be actually relied upon by the other side to the effect that look here, it is permissible. So therefore Aadhaar may not, it's created more confusion rather than given the clarity.
But does the Aadhaar judgment mean that only Indian laws will apply to foreign-seated arbitrations between Indian parties? Well, lawyers seem to be divided on this question.
Let us examine that aspect. What happens? Two Indian parties saying that look here, we'll decide our contractual disputes in the foreign-seated arbitration. Maybe the substantive law be Indian law, but the seat is outside the country. In that case, the post-Balco scenario, the part 1 would not apply, and in that case, again the parties will be then eventually permitted to derogate from the Indian law, which is now held in the Aadhaar also. That's against the public policy of India. So therefore, there is a problem here. So in that case, yes, one would tend to argue that by virtue of this judgment, it could be said that there is no choice but to go by the Indian parties should apply for the Indian law, and seat also should be in India.
No, in fact, the judgment itself recognizes in paragraph 8 that parties could have opted for a seat of arbitration which was outside India, and had they in such an event chosen an applicable law which was non-Indian, that law would have governed. As in this case, the court held that had the parties decided that England would be the seat of arbitration, then in that event, that Singapore would have been the seat of arbitration, then there would have been no difficulty in holding that English law applied. So it did not seek to restrict the application of Indian law alone in cases of disputes between two parties. It upheld the right of the parties to accept a foreign law as governing the rights of the parties.
So are there any lessons to be learned by Indian parties from this particular case?
I think that the only care which Indian parties would have to take, were they to be desirous of ensuring that they are not sucked into section 28 as it were, would be to have a clear and unambiguous reference to a foreign jurisdiction as the seat of arbitration. It would also apply very often even in domestic contracts, when parties in the event of disputes could refer their claims in one or many jurisdictions, provide for exclusive jurisdiction clauses in their contracts. All that requires to be done is to provide for such exclusive jurisdiction by ensuring that you don't give options and multiple choices.
Well, if this case does go up to the Supreme Court in appeal, then lawyers can only hope that the Apex Court clarifies the law on this subject once and for all. In Mumbai, Aayush Ailawadi.
All right, before I wrap up, here's some good news. Earlier this week, the government announced its intention to not levy MAT, or minimum alternate tax, on foreign companies that do not have a place of business in India. So now, foreign portfolio investors and some foreign companies in India are exempt from MAT. Others with a place of business, such as liaison offices, project offices, and those with a permanent establishment in India, well, get ready for MAT notices. Watch my discussion with Mukesh Bhutani and Daksha Bakshi on the firm website. That's thefirm.moneycontrol.com. Thanks for watching. We'll see you next week.
The Firm, India's only show on corporate law, tax and audit matters.